Okay, good afternoon. Okay, bali, okay, nag-stop tayo before sa Article 1174 ng Civil Code on fortuitous event. Okay, di ba, under Article 1174, except as otherwise provided for by law or otherwise provided for by stipulation, or when the nature of the obligation requires the assumption of risk, no person shall be responsible for those events which cannot be foreseen or though foreseen were inevitable. Kaya ang general rule natin is no person shall be responsible in case of a fortuitous event. Ang exception lang natin, law, okay, second stipulation, and third nature ng obligation requires the assumption of risk. Okay, now under law, di ba pag meron ng legal delay, kasi once na meron ng legal delay on the part of the debtor, meron ng mora solvendi, okay, even if the determinate object is lost by a fortuitous event, the obligation is not extinguished because this will be converted into a monetary obligation for damages. Second is bad faith. Kasi nga nag-promise kang i-deliver yung same object sa different person, okay, would not have the same interest. Number 3 is loss of generic thing kasi mag-apply yung doctrine of genus non quam perit or generic never perishes. At yung number 4, obligation arising from crime. Kasi di ba under Article 104 ng Revised Penal Code, ang civil liability is restitution, reparation, saka indemnification for consequential damages. Number 2, yung express stipulation dito. Okay? At number 3, nature ng obligation requires the assumption of risk. Okay, I repeat, dun sa, sabi ng Supreme Court in several cases kasi, hindi porke merong 40 event, automatic, okay, obligation ng debtor is extinguished. Okay? Pwede pa rin maging liable ang debtor pag hindi na-comply lahat ng requirement. Okay? Okay, first, the cause of the unforeseen and unexpected occurrence or the failure of the debtor to comply with obligation must be independent of human will. Okay, second, it must be impossible to foresee the event which constitute the cause of fortuito or it can be foreseen. It must be impossible to avoid. Number 3, the occurrence must be such as to render it impossible for the debtor to fulfill his obligation in normal manner. And last, the obligor must be free from any participation in the aggravation of the injury resulting to the creditor. Okay, kalimitan ito yung laging okay na miss. Kaya nagiging liable yung debtor even in case of a fortuitous event. Kasi once na nagkaroon ng okay contributory negligence on the part of the debtor, okay, then liable pa rin ang debtor even in case of a fortuitous event. Okay, equivalent term for fortuitous event, bali first, caso fortuito, ito yung literal translation natin. Second is act of God, like yun nga, lightning, okay, volcanic eruption, tornadoes, typhoon. Yung force majeure, di ba, like act of man ito eh, yung war or armed robbery, meaning robbery by using force or intimidation, pwede siyang mag-fall under force majeure. Okay, pero take note that, okay, robbery by using force or intimidation is not per se a fortuitous event. Kasi pwedeng may instances na negligence pa rin on the part of the debtor, kaya kahit merong, okay, armed robbery, okay, or robbery by using force or intimidation, okay, the obligation of debtor is not extinguished. Another is the unavoidable accident like tire blowout. Yeah. Okay, doon sa case ng National Power Corporation versus Court of Appeal, okay, dito nagkaroon ng typhoon. Okay? Bigyan natin yung facts. Bali sabi, in the early morning of hours of October 27, 1978, at the height of Typhoon Kading, a massive flood covered the town near Angat Dam, particularly the town of Norsagaray, causing several deaths and the loss and destruction of houses, farms, plants, working animals, and other properties of the people residing near the Angat River. Private respondent recalled that on the said day, they were awakened by the sound of rampaging water all around them. The water, okay, came steeply and strongly that before they could do anything to save their belongings, their houses has submerged. Okay, some even swept away by the strong current. A number of people were able to save their lives only by climbing trees. Private respondent blamed the sudden rush of water to the reckless and imprudent opening of all the 3 floodgates of the Angat Dam spillway without prior warning to the people living near or within the vicinity of the dam. Okay, at 21 hours of 2100 of October 26, 1978, NPC started to open the 3 floodgates simultaneously from 1 meter to 8 meters at 100 hours of October 27, 1978 until all floodgates were opened to the maximum 14 to 14.5 meters by 0600 hours of the same day. Okay, issue is NPC negligent and therefore liable for damages. Kasi dito ang defense kasi dito ng NPC is there is a typhoon. Okay, yun nga typhoon kading. Okay. Now, ang problema is that sabi ng Supreme Court dito, meron kasing negligence on the part of the NPC. Unang-una, inopen nila yung 3 floodgates ng dam simultaneously. Okay, tapos tingnan nyo naman kung anong oras inopen. Okay, medyo 9 o'clock na yan. Okay, tapos madaling araw. Okay, sabay-sabay nang inopen yung 3 floodgate nga ng dam. Okay, now, hindi nakapag-prepare of course dito yung mga complainant. Kaya ang naging issue, negligent ba ang NPC? Sabi ng Supreme Court is, yes. Okay, even though, meron ditong typhoon which is a fortuitous event, absent yung requirement number 4 kasi merong contributory negligence on the part of NPC. Kaya sabi ng Supreme Court dito, the obligor cannot escape liability if upon the happening of fortuitous event or an act of God, a corresponding fraud, negligence, delay, or violation or contravention in any manner of the tenor of the obligation as provided in Article 1170 of the Civil Code which result in loss or damage. In the case at bar, although the typhoon kading was an act of God, petitioner cannot escape liability because their negligence was the proximate cause of the loss and damage. It has been held in several cases that when the negligence of the person concurs with an act of God producing a loss, such a person is not exempt from liability by showing that the immediate cause of the damage was the act of God. To be exempt, he must be free from any previous negligence or misconduct by which the loss or damage may have been occasioned. Kaya titingnan nyo, pag ang proximate cause ng loss is due to fortuitous event, obligation ng debtor extinguished. Pero pag ang proximate cause ng loss is due to the negligence on the part of the debtor, i-convert yan into monetary obligation for damages. Okay? Now, another case, tingnan natin tong case ng Japan Airline versus Court of Appeal. Okay, dito naman, ang case na to, nagkaroon ng volcanic eruption, yung Mount Pinatubo. Okay, meron ditong bali 4 passengers na Pilipino. Okay, ito si Jose Miranda, Enrique Agana, Maria Angelina Agana, sa Cadelia Francisco. Si Jose Miranda, ang kanyang destination is from San Francisco, California, bound for Manila. Tapos si Enrique Agana, Maria Angelina Agana sa Cadelia Francisco. Ang destination is from Los Angeles, California, bound for Manila. By the way, hindi ito direct flight. Bali, ang flight nila is from US. Okay, dadaan muna to ng Japan. Okay, then Japan to Philippines. Okay, now on June 14, 1991, upon arrival at Narita, Japan, private respondent were billeted at Hotel Nico Narita for the night. Pagdating ng June 15, 1991, eto nga, nagkaroon ng flight cancellation because the eruption of Mount Pinatubo. Okay, kasi nga because of the ash fall, and inaccessible to airline traffic. Okay, pagdating dito, sabi ng JL revoke, all the Manila-bound passenger on flight number 741 due to the depart on June 16, 1991 and also paid for hotel expenses for their unexpected overnight stay. Okay, di ni-reschedule siya, di ba, ng June 16. Ang problema, pagdating ng June 16, 1991, nagkaroon na naman ng flight cancellation. Okay, due to NAIA's indefinite closure. Pero dito, hindi na sinolder ng Japan Airline yung hotel accommodation, and mga expenses paid by the, passenger. Kaya sabi dyan, at this point, JL informed the private respondent it would no longer defray their hotel and accommodation expense during their stay in Narita. Now, since NAIA was only reopened for airline traffic on June 22, 1991, private respondents were forced to pay for their accommodation, okay, and meal expenses from their personal fund, okay, from June 16, okay, to June 21, 1991. The unexpected stay in Narita, bale, ended on June 22, okay, 1991, okay, when they arrived on Manila on board jail flight number 741. On July 25, 1991, okay, nag-commence sila ng action for damages, okay, before the Regional Trial Court ng Quezon City, Branch 104. And the trial court, itong RTC, nag-render ng judgment. Sabi ng Regional Trial Court, okay, bayaran daw dito si, okay, itong passenger na, okay, apat, ato si Enrique Agana, Maria Helena Agana sa Cadilla Francisco, okay, ng 1,246,936. Okay, tapos si Jose Miranda naman, 320,616.31 as actual, moral, and exemplary damages at magbayad raw ng attorney's fee in the amount of 200,000 pesos at bayaran yung cost of litigation. Okay, ang Japan Airline nag-appeal before the Court of Appeal, and the Court of Appeal, okay, render judgment naman dito, inaward yung moral damages, okay, pero ni-reduce ng 200,000 for each plaintiff. Tapos exemplary damages to 300,000, tapos in attorney's fee, 200,000 plus the cost of litigation. However, pag akyat ng Supreme Court, sabi ng Supreme Court, tanggalin daw lahat ng damages na inaward. Walang actual, moral, and exemplary damages. Pero bigyan daw ng nominal damages yung each passenger ng 100,000 each, including attorney's fee of 50,000 plus the cost of suit or cost of litigation. Now, i-distinguish natin dito yung damages. Di ba, under the civil code, meron tayong okay kind of damages. Ito yung mental, moral, exemplary, nominal, temperate, actual, saka liquidated damages. Okay, ano ba yung ibig sabihin ng moral damages? Yung moral damages, ina-award natin by reason of physical or mental suffering. Nag-suffered ka ng sleepless night, wounded feeling, moral shock, serious anxiety, besmirched reputation, or other similar injury, then proper ang award ng moral damages. Yung exemplary naman, ina-award to by reason of okay, bad faith, wanton, or malevolent act. Okay, kaya dapat ma-prove na muna dito na merong bad faith. Okay, now, yung nominal damages naman, ina-award to, okay, just to vindicate a right. Okay, para ma-recognize yung right ng plaintiff na binayolate ng defendant. Okay, kaya tandaan nyo, pag nominal damages, okay, ang purpose niyan is to vindicate a right. Okay, para ma-recognize daw yung right ng plaintiff na binayolate ng defendant. Yung temperate damages naman, ina-award to, okay, kasi meron kang pecuniary loss, but by nature of the case, you cannot prove your actual damages, kaya na-award na lang si temperate damages. Now, yung temperate damages is less than actual, but more than nominal damages. Yung actual or compensatory damages, ina-award to pag meron kayong proof of pecuniary loss. Kasi pag wala kayong proof of pecuniary loss, then the court cannot award, okay, an actual or compensatory damages. Okay, and last, yung tinatawag nating liquidated damages. Yung liquidated damages, ina-award naman to kasi meron ng agreement yung parties beforehand that in case of breach, this would be the damage to be awarded. Tulad ng obligation with a penal clause. Okay, di ba sa penal clause, meron ng agreement yung contracting parties beforehand na pag nagkaroon ng breach, okay, ito yung okay, penalty. Okay, and a penal clause, of course, is the nature of a liquidated damages. Now, bakit tinanggal ng Supreme Court, okay, yung actual, moral, exemplary damages? Kasi sabi ng Supreme Court dito, indeed, to hold JAL in the absence of bad faith or negligence, liable for the amenities of a stranded passenger by reason of fortuitous event is too much of a burden to assume. Kasi sobra-sobra naman yan. In the absence of bad faith on the part, okay, bad faith or negligence on the part of Japan Airlines. Kasi nga, this is a fortuitous event. Okay, in fact, sinasabi pa ng Supreme Court dito, even though ang common carrier are bound mag-exercise ng extraordinary diligence, but okay, they are not insurer of all risks. Kasi every time daw you travel, especially by air, talagang merong okay, okay, risk ng change ng climatic condition na dapat i-assume ng passenger. Kaya sabi pa ng Supreme Court dito, furthermore, it has been held that airline passengers must take such risks incident to the mode of travel. In this regard, adverse weather conditions or extreme climatic changes are some of the perils involved in air travel, the consequence of which the passenger must assume or expect. After all, common carriers are not insurer of all risks. Okay, pero bakit nag-award ang Supreme Court ng nominal damages? Kasi ang reason kasi daw dito, okay, ang contract daw kasi ng Japan Airline, okay, with the passenger, i-transport nila yung passenger from US, okay, to Philippines, not US to Japan Airline, to Japan. Okay, ang problema dito, dapat yung Japan Airline kasi ang gumawa ng necessary arrangement for the next available flight back to Manila. Sabi ng Supreme Court, hindi man lang daw kinonsidered ng okay, Japan Airline yung convenient and comfort ng stranded passenger. Kaya para ma-recognize yung right ng mga passenger, okay, na binayolate ng airline company which is the Japan Airline, then proper ang award ng nominal damages. Okay, from the wording of the Supreme Court, sabi dito, we are not prepared, however, to completely absolve petitioner, JL, from any liability. It must be noted that private respondent bought ticket from the United States with Manila as their final destination. Papatayin sila, di ba? While Japan okay, Airline was no longer okay, required to defray private respondent living expenses during their stay in Narita on account of fortuitous event, JL had the duty to make the necessary arrangement to transport private respondent on the first available connecting flight to Manila. Petitioner JL reneged on his obligation to look after the comfort and convenience of his passengers, while it declassified private respondent from transit passengers to new passengers. As a result of which, private respondents were obliged to make the necessary arrangement themselves for the next flight back to Manila. Private respondents were placed on the waiting list from June 20 to June 24. To assure themselves of a seat on the available flight, they were compelled to stay in the airport the whole day of June 22, 1991, and it was only at 8 p.m. of the first date that they were advised that they could be accommodated and said flight which flew at about 9 a.m. the next day. Actually, kung ang ginawa dito ng Japan Airline, sila yung gumawa ng necessary arrangement for the next available flight back to Manila, dapat hindi liable ang Japan Airline. Okay, dito lang nagkamali ang Japan Airline. Okay? Kasi din sila gumawa ng necessary arrangement for the next available flight back to Manila. Kumbaga, pinabayaan na lang nila okay yung mga okay passenger. In fact, dineclassified pa nila from transit to new passenger. Okay, I repeat, pag merong combination ng fortuitous event and negligence, tingnan nyo yung proximate cause. Pag ang proximate cause ng loss is due to fortuitous event, obligation ng debtor extinguished. Pero pag ang proximate cause ng loss is due to negligence on the part of the debtor, then obligation is not extinguished, i-convert yan into monetary obligation for damages. Okay, now punta naman tayo dun sa duty ng debtor to give a generic thing. Now, manonotice nyo sa obligation ng debtor to deliver a generic thing, okay, wala kayong duty to preserve the thing pending delivery. Wala kayong duty to deliver the fruits. Wala kayong duty to deliver the accession and accessory. For obvious reason, okay, kasi nga since generic siya, okay, it belongs only to a certain class or genus. Kaya anong i-preserve mo? Okay, hindi mo rin, okay, alam kung anong i-deliver mo, kaya ano yung fruits. Okay, ano rin yung accession sa accessory. Kaya ang obligation lang ng debtor, okay, pag ang object is generic thing, number one, i-deliver lang yung thing based on the quality intended by the parties. And second, to be held liable for damages in case there is breach. Okay, now, example. I am the debtor, you are the creditor. Okay, my obligation to you is to deliver a determinating. Ang problema yung debtor ayaw mag-deliver ng determinate object. Ano ang remedy ng creditor? Okay, number one, you can ask for a specific performance. Okay, pwede ka mag-demand, okay, okay, na i-compel yung debtor na i-deliver yung determinate object. Second question, can the creditor, okay, as a remedy, pwede ba niyang i-compel yung debtor, okay, na mag-deliver, okay, pwede bang i-compel ng creditor, okay, yung debtor, okay, na bumili ng object at the expense ng debtor? Okay, the answer of course is no. Kasi nga since ang object ay determinating, it means only the debtor can perform it. Okay? Kaya ang remedy lang is okay, only for a specific performance. Okay, pangalawa, pwede rin kayo mag-ask ng pure damages. Pero you cannot ask a debtor to perform at the expense ng debtor. Okay, now punta tayo pag ang obligation is mag-deliver ng generic thing. Okay, number one, okay, ako yung debtor, ikaw yung creditor. My obligation is to deliver a generic thing. Okay, hindi nag-deliver ang debtor. Okay, ang question, can a creditor ask for a specific performance? The answer, of course, is yes. Pwede bang i-compel yung debtor na mag-deliver ng object based on the quality intended by the parties? Pangalawa, you can ask a third person to perform at the expense ng debtor. Kasi kung halimbawa, ang obligation ng debtor mag-deliver ng 1,000 sacks of rice, ayaw mag-deliver ng debtor, edi pwede mo siyang bilhin sa iba at the expense ng debtor. Okay. Now next, pwede ka rin mag-file ng action for pure damages. Okay, now punta naman tayo sa okay, personal obligation. Yung personal obligation, pwede siyang positive, pwede siyang negative. Yung positive personal obligation, I'm referring to obligation to do. Pag negative personal obligation, the obligation not to do. Okay, now, okay, mapapansin mo dun sa positive personal obligation. Meron ditong tatlong scenario. Number one, the debtor refused to perform. Second, the debtor performed but in a poor manner. Okay, number three, the debtor performed but in contravention ng tenor ng obligation. Okay, now, illustration. I am the debtor, you're the creditor. My obligation, for instance, is okay to do. Okay, sabi natin, my obligation is to paint the house. Okay, ang problema, yung debtor ayaw mag-perform. Question, can a creditor ask for a specific performance? The answer is no. Kasi pag obligation to do, specific performance is not a proper remedy because that is tantamount to involuntary servitude. Kaya anong remedy to ng creditor? Ang remedy ng creditor, okay, action for damages lang. Pero by the way, paki-check niyo yung obligation to do. Kasi pag halimbawa yung obligation to do is strictly personal, okay, ibig sabihin only the debtor can perform it, then action for pure damages lang. Pero pag obligation to do is not strictly personal, halimbawa, ang obligation ng debtor, okay, mag-repair, okay, ng television. Okay? Kung hindi naman siya strictly personal, then dalawang remedy ng creditor. Either number one, okay, pwede ka mag-ask ng pure damages. Number two, you may ask a third person to perform at the expense ng debtor. Pwede mo siyang ipa-repair sa iba at the expense ng debtor. Okay, yung pangalawa na scenario, yung debtor nag-perform pero in a poor manner. Example, yung obligation ng debtor, okay, i-paint yung house, okay, color white. Nag-paint nga yung debtor, pero tabi-tabingi. Okay? In a poor manner siya. In that case, okay, you may ask, okay, that it be undone at the expense of the debtor. Okay, third, okay, illustration. Third scenario. Yung debtor nag-perform, pero in a poor manner. Halimbawa, yung obligation ng debtor, Okay, i-paint yung house, okay, ng creditor, color, white. Nag-paint naman yung debtor. Perfect nga eh. Kulay black nga lang. Kaya lumalabas, nag-perform yung debtor, pero in contravention ng tenor ng obligation. Kaya ang revenue ng creditor, you may ask that it be undone at the expense ng debtor. How about yung negative personal obligation? Okay, ibig sabihin yung debtor, okay, prohibited to perform an act. Okay, pero nag-perform pa rin siya. In that case, ang remedy, okay, pwede kang mag-ask na it be undone at the expense ng debtor. Example, okay, the debtor, for instance, is prohibited to construct a fence on this parcel of land. Ang problema yung debtor, nag-construct pa rin ang fence. In that case, the creditor may ask that it be removed at the expense of the debtor. Okay, now, punta tayo doon sa kind of damages. Di ba sabi ko nga sa kinds of damages, okay, meron na acronyms dyan, mental. Bali, moral, exemplary, nominal, temperate, actual, saka liquidated damages. Yung moral damages, ina-award dyan by reason of physical or mental suffering. You suffered a sleepless night, wounded feeling, moral shock, serious anxiety, best representation, or other similar injury. Okay, exemplary or corrective damages. Okay, dapat dito ma-prove na merong bad faith, merong wanton or malevolent act. Kaya nga ini-impose yan by way of example or correction. Kaya tinawag siyang exemplary to set as example. Example or correction for the public good. It may be awarded if the defendant acted in wanton, fraudulent, reckless, oppressive, or malevolent manner. Yung nominal damages naman, ina-award to just to vindicate nga a right. Para ma-recognize yung right ng plaintiff na binayolate ng defendant. Kaya sabi dyan, adjudicated in order that a right of the plaintiff which has been violated or invaded by the defendant may be vindicated or recognized and not for the purpose of identifying the plaintiff for any loss suffered by him. Awarded in every case where any property right has been invaded. Yung temperate naman, sabi ko nga, bali more than actual yan, pero less than. Okay? Less than actual, but more than nominal. Okay, kaya nakalagay dyan, more than nominal, okay, but less than actual. Awarded when some pecuniary loss has been suffered. Okay, meaning meron kang pecuniary loss, but it amount cannot, okay, from the nature of the case, be proved with certainty. Kasi di ma-prove yung actual damages, ina-award na lang yung temperate. Yung actual or compensatory naman, value of loss suffered only include profits which the creditor failed to obtain. Pecuniary loss must be duly proved. Kaya dapat meron kayong proof of pecuniary loss. Liquidated naman, those agreed upon by the parties to the contract to be paid in case of breach. Okay? Kaya dito, example niyan nga yung obligation with the penal clause. Okay, how about yung breach of promise to marry? Okay, yun bang breach of promise to marry is an actionable wrong. Now, sabi ng Supreme Court, general rule, breach of promise to marry is not an actionable wrong. Halimbawa, si A nag-promise kay B, pakakasalan niya, tinanggap naman ni B ang promise ni A. Later on, si A nag-breach. Okay, ang problema si B, nag-suffer siya ng sleepless night, wounded feeling, moral shock, di ba? Okay, stress, anxiety, best reputation. Okay, ang tanong, makaka-recover ba siya ng moral damages? The answer is no, as a rule. Kasi nga, okay, yung mere physical or mental suffering, okay, hindi yan, okay, ina-award ka agad, okay, for moral damages. Okay? Kasi nga yung mere breach of promise to marry is not an actionable wrong. Kaya ibig sabihin, hindi lahat ng sakit na nararamdaman mo ay makaka-recover ka ng moral damages. Okay, pero let us modify. Paano kung halimbawa si A, nag-promise kay B, napapakasalan niya. Okay, because of this promise, nagkaroon na ng necessary preparation. Okay, si B bumili na ng wedding gown, nagpa-reserve na kayo sa hotel, okay, nagbigay na kayo ng invitation, okay, tapos nagkaroon na kayo ng publication sa newspaper of general circular. Kumbaga lahat prepared na. Tapos, on the date ng celebration ng marriage, biglang umatras itong si A. In that case, pwede na kayo makarecover ng moral damages. Kaya sabi ng Supreme Court, may dalawang cases na dito. Okay na exception. Number one, when a woman is a victim of moral seduction. Okay, sinijus. Okay, sinijus itong babae kunwari. Okay, nakuha yung kanyang okay, pagkababae. Now, in that case, pwedeng mag-award ng moral damages. Yung number two, ito nga, formally set a wedding and go through all the above. Okay, describe preparation and publicity only to walk out of it when the matrimony is about to be solemnized. Yan yung case ni Beatrice T. Wasmer versus Francisco X. Velez. Okay, on the date ng celebration ng marriage, biglang nag-withdraw. Okay, kung napanood ninyo yung pelikula ni My Amnesia Girl, di ba? Itong si John Lloyd, yung date ng celebration ng marriage nila, dapat biglang umatras, hindi nagpakita. Siyempre, ang laking kahihiyan yun sa part ng babae. Kaya yan, pwede ka mag-recover ng moral damages. Pero kung mere breach of promise to marry lang, okay, hindi yan, okay, an actionable wrong. That is the general rule. Okay, dito naman sa case ng Agabon versus NLRC, nag-award dito ang Supreme Court ng nominal damages na 30,000. Dito meron kasing just cause for dismissal pero hindi nagkaroon ng observance ng procedural due process. Kasi di ba under the labor code, okay, bago ka mag-dismiss ng employee, okay, ng regular employee, dapat merong just cause or authorized cause at pangalawa, nagkaroon ng observance ng procedural due process. Okay? Kaya para ma-recognize yung right ng okay employee na hindi inobserve ng employer, then dito nagkaroon ng award ng nominal damages na 30,000 pesos. How about usury? Okay, under Article 1175, usurious transaction should be governed by special law. Di ba magsabing usury law, ito yung law na nagpro-provide ng maximum ceiling of interest in case of loan or forbearance. Ang problema lang, ang usury law is now ineffectual. Kasi pursuant to Central Bank Circular 905, which took effect on December 22, 1982, sabi ng Supreme Court, okay, the usury law now become non-existent in our jurisdiction. Kaya lumalabas, okay, at present, the contracting parties are now free to stipulate as to any amount of interest, wag lang siyang too excessive or unconscionable. Kasi pag yan ay too excessive or unconscionable, pwede siyang i-declared as void. Pero not being contrary to law, because there is no more usury law, but being contrary to moral. Magiging contra bonus mores na siya. Now, sabi ng Supreme Court dito in the case of Florendo versus Court of Appeal, the court reiterated the ruling that by virtue of Central Bank Circular 905 nga, adopted on December 22, 1982, the usury law has become rendered ineffective. Usury has been legally non-existent in our jurisdiction. Interest cannot be charged as lender and borrower may agreed upon provided it's not iniquitous or unconscionable. Pero sabi ng Supreme Court sa case ng Middle, yung 5.5% per month or 66% per annum, okay, is void. Not being contrary to law, but being contrary to moral. Naging kontra bonus mores siya. In another case, sabi ng Supreme Court sa case ng BPI versus Fulton, 3% per month or 36% per annum was declared excessive. Okay? Void rin daw to. Kaya nangyari dyan, the court reduced the penalty charge thereon for late payment at the rate of 36% per annum to 12% per annum. Interest is stipulated upon by the parties in the promissory note at the rate of 36% is iniquitous and conscionable, citing the case of Corazon versus versus Court of Appeal. Okay, pero sabi ng Supreme Court sa case ng Garcia versus Court of Appeal, 20% per annum is valid. Syempre, lalo na yung 21% sa case ni Bautista versus Pilar. Pero malamang ang tanong nyo is, kung valid yung 24%, void yung 36%, paano yung in between? Okay, answer, hindi ko alam. Okay? Kasi pwedeng i-declare dyan ng court na iniquitous or unconscionable. Depende yan, of course, sa court. Kaya court ang magde-determine whether or not yung interest ba dito ay excessive or unconscionable. Kaya pero dito yung 24%, sinabi na dyan na void, na valid siya. Pero yung 36% void, yung in between yung problem natin. Okay, pero kung titingnan mo yung case ng Macalinao versus BPI, ito sa credit card to. Doon sa credit card kasi, meron nakalagay na stipulation doon, di ba? Pag di ka nagbayad on time, okay, meron niyang penalty charge plus interest pa. Okay, kung titingnan nyo, ito yung nakalagay na stipulation, payment of charges. The charges or balance thereof remaining unpaid after the payment due date indicated on the monthly statement of account shall bear interest at the rate of 3% per month for BPI Express Credit Card, BPI Gold Mastercard, and additional penalty fees equivalent to another 3% of the amount due for every month or fraction of month delay. Kaya ibig sabihin may 3% penalty charge siya plus 3% interest on the outstanding balance. Pero sabi ng Supreme Court dito, excessive daw yan. Sabi ng Supreme Court, BPI originally imposed the interest and penalty charge at the rate of 9.25 per month, 3.25 finance charge, and late payment charge equivalent to 6% of the amount due, or 111% per annum being void being iniquitous. Kaya ang ginawa sa Supreme Court, ni-reduce lang siya ng 1% penalty charge saka 1% interest. Sabi ng Supreme Court, justified yung court na i-reduce yung penalty charge pursuant to Article 1229 ng Civil Code. Kasi 'di ba meron tayong dalawang instances wherein the court is authorized to reduce the penalty. Number 1, pag merong partial or regular performance, at number 2, even without partial or regular performance but the penal clause is iniquitous or unconscionable. Now dito, since yung penal clause is iniquitous or unconscionable, then the court daw is authorized to reduce the penalty. Okay, now let us proceed now sa presumption. By the way, meron tayong dalawang presumption under the law. Number 1, yung tinatawag na conclusive presumption, saka second is rebuttable. Pag sinabing conclusive presumption, it means ito yung presumption ng batas, pero hindi kayo allowed mag-present ng contradictory evidence para i-rebut yung presumption. Okay, example nito is Article 3 ng Civil Code, ignorance of the law excuses no one from compliance therewith. Pero pag sinabing rebuttable presumption, ito yung presumption ng batas, okay, pero allowed kayong mag-present ng contradictory evidence to rebut the presumption. Okay, example nito, all accused are presumed innocent until proven otherwise. Okay, tingnan mo natin. May example din ng mga conclusive presumption. Okay, doctrine of estoppel. Okay, sa rules of court under Rule 131, Section 2. The tenant is not permitted to deny the title of his landlord at the time of commencement of the relation of landlord and tenant between them. And of course, yung number 3, yung Article 3 ng Civil Code. So disputable, rebuttable yun nga. The person innocent of crime or wrong, that unlawful act was done with unlawful intent, that a person intend the ordinary consequence of his voluntary act. Yung Article 1176, this is a rebuttable presumption. Kasi allowed kayo mag-present ng contradictory evidence para i-rebut yung presumption. Tulad nitong first paragraph, the receipt of the principal by the creditor without reservation with respect to the interest shall give rise to the presumption that said interest has been paid. Ibig sabihin, kapag ang creditor ay nag-issue ng resibo para sa principal pero walang reservation sa interest, the presumption is that the interest is already paid. Kasi by the way, kasi doon sa rules on payment, di ba sabi doon, in payment, you need to apply first the payment to the interest before you can apply to the principal. Kaya hindi pwedeng insist ng debtor na yung payment niya i-apply ka agad sa principal pag hindi pa bayad yung interest. Kaya once nang-issue na ang creditor ng receipt pertain to the principal without reservation of the interest, the presumption is that the interest is already paid. Pero by the way, rebuttable yan kasi allowed ang creditor mag-present ng contradictory evidence na hindi pa bayad yung interest. Pero pag hindi siya nag-present ng contradictory evidence, then magpre-prevail yung presumption that the interest is already paid. Yung second paragraph, okay, rebuttable din to. The receipt of latter installment of a debt without reservation as to the prior installment shall likewise raise the presumption that such installment has been paid. Example, the debtor is indebted to the creditor for, okay, 120,000. Payable siya on installment from January to December. Ang problema, pagdating ng April, okay, nagbayad for instance ang debtor ng 10,000. At ang creditor nag-issue ng resibo for April installment. Ang presumption niyan, January, February, saka March installment payment is already paid. Okay. Now, pero how about sa taxes? Okay, halimbawa, okay, 2009. Okay, 2020 for instance, year 2020. Nagkaroon na ng payment for instance ng okay, sabihin natin nagkaroon ng payment ng 2020 taxable, okay, tax due. May presumption ba na yung 2018, 2019 bayad na? The answer of course is no. Okay, ito nag-a-apply to sa obligation arising from okay, contract. Okay, now let us proceed now sa Article 1177. Okay, the creditor now after having pursued the property in possession of the debtor to satisfy their claims may exercise all the rights and bring all the action of the latter for the same purpose, save those which are inherent in his person. They may also impugn the act which the debtor may have done to defraud them. By the way, merong 4 na remedy ang creditor against the debtor. Number 1, exact fulfillment, exhaust all properties ng debtor general attachment, action subrogatoria, at last yung action pauliana. To illustrate, halimbawa yung debtor is indebted to the creditor for 1 million. Ang unang remedy ng creditor, exact fulfillment. Ang problema, ang available cash lang ng debtor, 200. Kaya 1 million minus 200, meron pang unpaid obligation na 800,000. Anong second remedy ng creditor? I-exhaust daw lahat ng properties ng debtor general attachment. Okay, example, yung debtor meron siyang property, okay, house and lot. Pwede ang i-attach at ibenta sa public sale. Kunwari, nabenta ng 400, kaya 800 minus 400, meron pang unpaid 400,000. Okay, anong third remedy ng creditor? Yung action subrogatoria. Halimbawa, yung debtor, meron siyang claim against third person. Receivables, collectibles. Lumalabas, yung original debtor dito, creditor to. Ito yung lumalabas na debtor. Pwedeng mag-exercise ang creditor ng right of subrogation. Okay? Action subrogatoria. Makukuha niya yung right ng debtor dito to collect. Kaya pwede niyang kolektahin yung receivables na 200. Ang tawag dyan, action subrogatoria. Okay, sa layman's term, pag sabing action subrogatoria, okay, substitution yan. Okay, substitution lang yan ng creditor. Kaya makokollect niya yung 200, kaya 400 minus 200, merong pang unpaid obligation ng 200. Ang last remedy ng creditor, yung tinatawag nating action pauliana. Okay, halimbawa, yung debtor may lupa. Abang ginawa, dinonate, nagkaroon siya ng donation, pero hindi siya nag-reserve ng sufficient property to pay creditors. Okay, now sa rescissible contract, di ba, may nakalagay doon na kapag nag-dispose ang debtor ng property by gratuitous title. Ano ba yung gratuitous? Donation, succession. At hindi ka raw nag-reserve ng sufficient property to pay creditors, that is a badges of fraud. Ibig sabihin, ang presumption ng batas, wala kang ibang intention kung hindi i-defraud ang creditor. Okay? Kapag ikaw ay nag-transfer or nag-dispose ng property by gratuitous title, at di ka nag-reserve ng sufficient property to pay creditor, badges of fraud siya. Kaya ulitin ko, yung ginawa mong donation, ang presumption ng batas, wala kang ibang intention kung hindi lokohin ang creditor. Kaya rescissible. Pwede siyang mag-file ng action for rescission. Okay, now ano ba yung requisite ng action pauliana? Sabi ng Supreme Court sa case ng Angkor Savings Bank versus Henry Purigay, GR number 191178, March 13, 2013, Okay? Natanong to actually before sa CPA board exam. Sabi dyan, for an action Pollyanna to accrue, the following requisite must occur. Number one, the plaintiff asking for rescission has a credit, okay, prior to alienation, although demandable later. Meaning may credit, may claim yung creditor against the debtor. Okay, although hindi pa siya demandable. Pangalawa, that the debtor has made a subsequent contract conveying a patrimonial benefit to third person. Isipin yung debtor nagkaroon ng subsequent contract, nagkaroon ng disposition, pwede siyang gratuitous, pwede siyang onerous. Pero I repeat, pag yan ay gratuitous, automatic ang presumption kaagad dyan, okay, ang intention ng debtor ay defraud yung creditor kung hindi ka nag-reserve ng sufficient property. Number three, that the creditor has no other legal remedy to satisfy his claim but would benefit by rescission of conveyance to third person. By the way, mapapansin mo kasi, yung rescissible contract, yung rescission doon, okay, sa paragraph C ng 1381, okay, isa subsidiary action and therefore pwede mo lang siyang i-exercise kung wala ka ng other available remedy. At next, that the act being impugned is fraudulent. Okay, dapat fraudulent daw. Okay, yung act na pag-dispose ng property. And last, that the third person who received the property conveyed it by onerous title has been accomplice in the fraud. Kaya dapat bad faith dito yung third person. Kasi kung halimbawa yung third person na acquired in good faith and for value, okay, isang limitation yan sa rescissible contract. Now, punta tayo dun sa last provision, sa general provision. Transmissibility of right. General rule, all rights acquired in virtue of obligation are transmissible. Kaya lahat daw ng right na na-acquired by breach ng obligation, general rule, transmissible. Ang exception lang, law. Okay, when the law so provide. Second, okay, agreement. Okay, contract provides otherwise. And last, obligation daw is purely personal. Okay, example under law. Okay, sa law on partnership, okay, yung right ng partner, okay, okay, hindi yan class transferable. Okay, ang natatransfer lang yung interest, okay, in the partnership. Okay, pero lumalabas yung right mo sa partner is, okay, non-transferable. Kaya di ba halimbawa, okay, ABC are partners, later on si A namatay. Okay, automatic the partnership is dissolved. Okay, hindi malilipat sa legal heirs yung right ni A as partner. Okay, ang matatransfer lang, okay, sa legal heirs yung interest in the partnership. Yung lang right to participate or mag-share sa profit and surplus upon dissolution. Pero yung lahat ng right ng partner, right to inspect partnership book, right to participate in management, hindi yan matatransferred sa legal heirs. Okay, another is contract of comodatum. Ang contract of comodatum kasi purely personal. That's why yung debt ng either bail or bailee, okay, will extinguish the comodatum. Okay, yung contract naman, of course, self-explanatory. Kailangan may express stipulation between the debtor and creditor, okay, na transmissible, okay, non-transmissible right siya. Okay, katulad yan sa lease contract for instance, sa contract of lease, di ba? Okay, pag na-terminate na, namatay for instance yung lessor lessee, tuloy pa rin yung lease contract. Okay, kasi transmissible right siya. Okay, o kaya yung obligation is purely personal. Nakakuha kayo ng, okay, scholarship grant from Harvard University. Hindi yan pwedeng i-transfer kasi purely personal. Okay, another is right to hold public office, for instance, is also non-transmissible right. Kaya si mayor, namatay. Okay, now, ibig sabihin, malilipat to sa kanyang legal heirs, no? Automatic, the vice mayor becomes the mayor. Okay, kasi nga yung right to hold public office is also a non-transmissible right. Di mo rin siya pwedeng ibenta. Okay, yan yung Article 1178. Now, let us proceed now sa multiple choice problem. Okay, the father, on his absence, the mother becomes liable for the damage that a minor son may cause to others, and the liability arises from, diba, letter A, delict, B, contract, C, quasi-delict, letter D is quasi-contract. Of course, the answer here is letter C, quasi-delict. Okay? Kasama yan dun sa Article 2180 ng Civil Code on Vicarious Liability. Another D is driver of passenger bus which is owned and operated by O. While D is driving said bus, it met an accident. Through his negligence where P, a passenger was injured. D is liable to pay for damages which arises from. Okay, by the way, ang tinatanong dito is hindi yung driver. Di ba sabi ko, may dalawang possible answer dyan actually. Pwede siyang crime or pwede siyang quasi-delict. Pero sabi ko before, kung driver, gawin nyo na lang siyang crime. Okay? Kaya ang sagot dito is letter B. Okay? Okay, punta tayo sa number 3. A mango tree is in the land of O, is reclining toward the road. All of a sudden, without a storm or earthquake or even a strong wind, okay, the tree falls hitting a car belonging to X, causing 20,000 damage. The liability of O to X arises from, nakalagyan specifically sa quasi-delict. The answer is letter D. Okay, multiple choice number 4. The diligence of a good father of family as required of person obliged to give simply means. Yung pag sabing diligence of a good father of a family, that is just an average diligence. Okay? Kaya ang sagot is letter C. Multiple choice number 5, this is delay in doing. Okay? By the way, sa number 5, wala kasi binigay siya is doing. To be obligation to do. Kaya ang sagot dyan is letter B. Okay? Mora solvendi ex persona. Kasi pag mora solvendi ex re, delay on the part of the debtor and obligation to give. Pag mora accipiendi, di ba? Delay on the part of the creditor. Pag compensatio mori, delay sa part ng both debtor and creditor. Okay. Multiple choice number 6. Statement 1, the law does not allow waiver of an action for future fraud. That is true. Kasi di ba sabi ng 1171, responsibility arising from fraud is demandable in all kind of obligation. Any waiver of an action for future fraud is void. Statement number 2, damage arising from fraud cannot be reduced or mitigated by the court, unlike damage arising from negligence, especially okay if there is contributory negligence. Okay, that is also true. Kaya ang sagot dyan is letter A. Okay, multiple choice number 7. The principle that no one shall be unjustly enriched or benefited at the expense of another is the basis of letter C. Okay, tandaan niyo yung quasi-contract. This is a lube act when certain lawful, unilateral, and voluntary act to the end that no person shall enrichly benefited at the expense of another. Multiple choice number 8. Which of these obligation is real in character? To paint a house is to do. To repair a car is to do. To write a book is to do. All of them. Okay? And of course, the answer is, okay, letter A. Kasi lahat yan is obligation to do. A personal obligation. Wala diyang real. Multiple choice number 9. A wife is under obligation to support her husband and it arises from letter A. Kaya, okay, ito, tinanong dati sa board exam, pero yun nga, yung contract of marriage daw, ang binanggit. Baka ma-confuse kasi nilagay contract of marriage. Okay? Yung duty ng husband and wife, of course, okay, is arising from, okay, not arising from contract, but obligation arising from law. Okay, multiple choice number 10. Delay or default on the part of the creditor is known as, of course, pag delay sa part ng creditor, we call it mora accipiendi. Sagot is letter C. Okay. Delay or default on the part of the obligor in giving is known as, okay, letter A. Bali, mora solvendi ex re. Kasi nakalagay dyan, giving. Yung mora solvendi ex persona, di ba? Delay on the part of the debtor in obligation to do. Mora accipiendi, delay on the part of the creditor. Compensatio mori is delay on both debtor and creditor. By the way, there is no legal delay in obligation not to do or not to give.
Kasi nagkakaroon lang ng legal delay sa positive obligation. Multiple choice number 12. This kind of damage is awarded for physical suffering, mental anguish, serious anxiety, wounded feeling, moral shock, serious humiliation, social humiliation, and the like. Of course, the answer here is letter B, moral damage. Okay. Number 13. Okay, this damage consists of a small amount but is awarded to vindicate a wrong, to redress a grievance. Okay, di ba sabi ko pag ang purpose is to vindicate a right? Okay, we called it nominal damage. Okay, letter C. Okay, multiple choice number 14, the due diligence in the selection or supervision of employee is a defense available in letter B. Culpa Kiliana. Okay? Kasi sa culpa Kiliana, di ba? Pwede kayong mag-set up ng defense dito na hindi ka liable because you exercise diligence of a good father of family in the selection and supervision of employee. Pero sa culpa contractual kasi, lalo na kung halimbawa common carrier yan. Okay? Hindi pwedeng sabihin ng common care na hindi siya liable kasi he exercised diligence of a good father of family in the selection and supervision of his employee, yung driver. Kasi the mere fact na na-injured yung passenger, that is a clear breach of contract. Doon naman sa crime, hindi rin defense yan sapagkat ang liability ng common carrier is automatic but subsidiary. Kaya dito ang sagot sa number 14 is letter B. Sa number 15, the following are the requisite for the filing of rescissory action. Okay, except ang sagot is letter B. The right and action are not purely personal or inherent in the person of the debtor. Kasi itong letter A, C, D, di ba? Kasama yan dun sa mga binanggit na requisite sa rescissory action. Okay? Yung letter B ang hindi kasama. Kaya ang sagot is boy. Okay, remember, life is a race. If you don't run fast enough, someone will overtake you and move faster. Okay, yan yung binanggit ni virus, di ba? Doon sa 3 ages. Okay? End of general provision, nature and effect of obligation. Okay?